Bhushan Jadhav's fate will be decided in just a couple of minutes. This is going to be a defining verdict, a landmark verdict, in fact, in the ties between India and Pakistan, how the case moves on from here on. It's a much larger issue, and we will be getting you a post-verdict analysis as well. For the viewers who are just tuning in, live visuals coming to you from The Hague, the 11-judge bench there. Judge Ronnie Abraham is all set to read out the verdict. This is a public sitting that is taking place in the Peace Palace in The Hague.
La Cour se réunit aujourd'hui pour rendre en audience publique sa décision sur la demande en indication de mesures conservatoires présentée par l'Inde dans l'affaire Jadhav, Inde contre Pakistan. Je rappellerai que le 8 mai 2017, le gouvernement de l'Inde a déposé au greffe de la Cour une requête introductive d'instance contre le Pakistan concernant des violations alléguées de la
of the Vienna Convention on consular relations in the matter of the detention and trial of an Indian national, Mr. Kulbhushan Sudhir Jadhav, sentenced to death in Pakistan. On the same day, India, referring to Article 41 of the Statute of the Court and to Articles 73, 74 and 75 of the Rules of Court, submitted a request for the indication of provisional measures aimed at safeguarding the rights it claims under the Vienna Convention, pending the Court's decision on the merits. In accordance with the usual practice, I shall not read the introductory paragraphs of the order, which set out the main elements in the procedural history of the case. I shall also omit or summarize some other paragraphs. I shall accordingly begin the reading of the order at paragraph 13. The context in which the present case has been brought before the court can be summarized as follows. Mr. Jadhav has been in the custody of Pakistani authorities since the 3rd of March 2016, although the circumstances of his arrest remain in dispute between the parties. India maintains that Mr. Jadhav is an Indian national, which Pakistan recognized in various notes verbales. The applicant claims to have been informed of this arrest on the 25th of March 2016, when the Foreign Secretary of Pakistan raised the matter with the Indian High Commissioner in Pakistan. As of that date, India requested consular access to Mr. Jadhav. India reiterated its request on numerous occasions to no avail. On the 23rd of January 2017, Pakistan sent a letter of request seeking India's assistance in the investigation process concerning Mr. Jadhav and his alleged accomplices. On the 21st of March and the 10th of April 2017, Pakistan informed India that consular access to Mr. Jadhav would be considered in the light of India's response to the said request for assistance. According to a press statement issued on the 14th of April 2017 by an advisor on foreign affairs to the Prime Minister of Pakistan, Mr. Jadhav was sentenced to death on the 10th of April 2017 by a court-martial due to activities of espionage, sabotage and terrorism. India submits that it protested and continued to press for consular access and information concerning the proceedings against Mr. Jadhav. It appears that under Pakistani law, Mr. Jadhav would have 40 days to lodge an appeal against his conviction and sentence. That is until 19th of May 2017. But it is not known whether he has done so. India states, however, that on the 26th of April 2017, Mr. Jadhav's mother filed an appeal under Section 133B and a petition to the federal government of Pakistan under Section 131 of the Pakistan Army Act 1952, both of which were handed over by the Indian High Commissioner to Pakistan's Foreign Secretary on the same day. The court may indicate provisional measures only if the provisions relied on by the applicant appear prima facie to afford a basis on which its jurisdiction could be founded, but need not satisfy itself in a definitive manner that it has jurisdiction as regards the merits of the case. In the present case, India seeks to found the jurisdiction of the court on Article 36, paragraph 1 of the Statute of the Court and on Article 1 of the optional protocol concerning the compulsory settlement of disputes, which accompanies the Vienna Convention on consular relations. I will refer to these instruments as the optional protocol and the Vienna Convention, respectively. The court must therefore first seek to determine whether Article 1 of the optional protocol prima facie confers upon it jurisdiction to rule on the merits, enabling it, if the other necessary conditions are fulfilled, to indicate provisional measures. India and Pakistan have been parties to the Vienna Convention since the 28th of December 1977 and 14 May 1969, respectively, and to the optional protocol since 28 December 1977 and 29 April 1976, respectively. Neither of them has made reservations to those instruments. The court recalls that the applicant seeks to ground its jurisdiction in Article 36, paragraph 1 of the statute and Article 1 of the optional protocol. It does not seek to rely on the parties' declarations under Article 36, paragraph 2 of the statute. When the jurisdiction of the court is founded on particular treaties and conventions in force pursuant to Article 36, paragraph 1 of its statute, it becomes irrelevant to consider the objections to other possible bases of jurisdiction. Therefore, any reservations contained in the declarations made by the parties under Article 36, paragraph 2 of the statute cannot impede the court's jurisdiction specially provided for in the optional protocol. Thus, the court need not examine these reservations further. Article 1 of the optional protocol provides that the court has jurisdiction over, I quote, disputes arising out of the interpretation or application of the Convention, Vienna Convention, end of quote. The Court will accordingly ascertain whether, on the date of the application was filed, such a dispute appeared to exist between the parties. In this regard, the Court notes that the parties do indeed appear to have differed, and still differ today, on the question of India's consular assistance to Mr. Jadhav under the Vienna Convention. While India has maintained at various times that Mr. Jadhav should have been and should still be afforded consular assistance under the Vienna Convention, Pakistan has stated that such an assistance would be considered in the light of India's response to its request for assistance in the investigation process concerning him in Pakistan. These elements are sufficient at this stage to establish prima facie that, on the date the application was filed, a dispute existed between the parties as to the question of consular assistance under the Vienna Convention with regard to the arrest, detention, trial and sentencing of Mr. Jadhav. In order to determine whether it has jurisdiction, even prima facie, the Court must also ascertain whether such a dispute is one over which it might have jurisdiction ratione materiae on the basis of Article 1 of the optional protocol. In this regard, the Court notes that the acts alleged by India are capable of falling within the scope of Article 36, paragraph 1 of the Vienna Convention, which, inter alia, guarantees the right of the sending state to communicate with and have access to its nationals in the custody of the receiving state, as well as the right of its nationals to be informed of their rights. The Court considers that the alleged failure by Pakistan to provide the requisite consular notifications with regard to the arrest and detention of Mr. Jadhav, as well as the alleged failure to allow communication and provide access to him, appear to be capable of falling within the scope of the Vienna Convention ratione materiae. In the view of the Court, the elements mentioned sufficiently establish at this stage the existence between the parties of a dispute that is capable of falling within the provisions of the Vienna Convention and that concerns the interpretation or application of Article 36, paragraph 1 thereof. The Court also notes that the Vienna Convention does not contain express provisions excluding from its scope persons suspected of espionage and terrorism. At this stage, it cannot be concluded that Article 36 of the Vienna Convention cannot apply in the case of Mr. Jadhav, so as to exclude on a prima facie basis the Court's jurisdiction under the optional protocol. The Court further considers Pakistan's argument that a 2008 bilateral agreement on consular relations, I quote, limits and qualifies or supplements, and of quote, the Vienna Convention, and that the Court therefore lacks prima facie jurisdiction under Article 1 of the optional protocol. The Court does not need to decide at this stage of the proceedings whether Article 73 of the Vienna Convention would permit a bilateral agreement to limit the rights contained in Article 36 of the Vienna Convention. It is sufficient at this point to note that the provisions of the 2008 agreement do not impose expressly such a limitation. Therefore, the Court considers that there is no sufficient basis to conclude at this stage that the 2008 agreement prevents it from exercising its jurisdiction under Article 1 of the optional protocol over disputes relating to the interpretation or the application of Article 36 of the Vienna Convention. Consequently, the Court considers that it has prima facie jurisdiction under Article 1 of the optional protocol to entertain the dispute between the parties. The Court then turns to the plausibility of the rights whose protection is sought and the link between those rights and the provisional measures requested. The power of the Court to indicate provisional measures under Article 41 of the Statute has as its object the preservation of the respective rights claimed by the parties in a case, pending its decision on the merits thereof. It follows that the Court must be concerned to preserve by such measures the rights which may subsequently be adjudged by it to belong to either party. Therefore, the Court may exercise this power only if it is satisfied that the rights asserted by the party requesting such measures are at least plausible. Moreover, a link must exist between the rights whose protection is sought and the provisional measures being requested. In its application, India asserts that the rights it is seeking to protect are those provided by paragraph 1 of Article 36 of the Vienna Convention. It follows from this provision that all states parties to the Vienna Convention have a right to provide consular assistance to their nationals who are in prison, custody or detention in another state party. They are also entitled to respect for their nationals' rights contained therein. At this stage of the proceedings, the Court is not called upon to determine definitively whether the rights which India wishes to see protected exist. It need only decide whether these rights are plausible. The rights to consular notification and access between a state and its nationals, as well as the obligations of the detaining state to inform without delay the person concerned of his rights with regard to consular assistance and to allow their exercise, are recognized in Article 36, paragraph 1 of the Vienna Convention. Regarding Pakistan's arguments that first, Article 36 of the Vienna Convention does not apply to persons suspected of espionage or terrorism, and that, second, the rules applicable to the case at hand are provided in the 2008 agreement, the Court considers that at this stage of the proceedings, where no legal analysis on these questions has been advanced by the parties, these arguments do not provide a sufficient basis to exclude the plausibility of the rights claimed by India. In the view of the Court, taking into account the legal arguments and evidence presented, it appears that the rights invoked by India in the present case on the basis of Article 36, paragraph 1 of the Vienna Convention are plausible. The Court now turns to the issue of the link between the rights claimed and the provisional measures requested. The Court notes that the provisional measures sought by India consist in ensuring that the government of Pakistan will take no action that might prejudice its alleged rights, in particular that it will take all measures necessary to prevent Mr. Jadhav from being executed before the court renders its final decision. The court considers that these measures are aimed at preserving the rights of India and of Mr. Jadhav under Article 36, paragraph 1 of the Vienna Convention. Therefore, a link exists between the rights claimed by India and the provisional measures being sought. The court then turns to the condition of risk of irreparable prejudice and urgency. The court, pursuant to Article 41 of its statute, has the power to indicate provisional measures when irreparable prejudice could be caused to the rights which are the subject of judicial proceedings. However, the power of the court to indicate provisional measures will be exercised only if there is urgency, in the sense that there is a real and imminent risk that irreparable prejudice will be caused to the rights in dispute before the court gives its final decision. The court must therefore consider whether such a risk exists at this stage of the proceedings. Without prejudging the result of any appeal or petition against the decision to sentence Mr. Jadhav to death, the court considers that as far as the risk of irreparable prejudice to the rights claimed by India is concerned, the mere fact that Mr. Jadhav is under such a sentence and might therefore be executed is sufficient to demonstrate the existence of such a risk. There is considerable uncertainty as to when a decision on any appeal or petition could be rendered and, if the sentence is maintained, as to when Mr. Jadhav could be executed. Pakistan has indicated that any execution of Mr. Jadhav would probably not take place before the end of August 2017. This suggests that an execution could take place at any moment thereafter, before the court has given its final decision in the case. The court also notes that Pakistan has given no assurance that Mr. Jadhav will not be executed before the court has rendered its final decision. In those circumstances, the court is satisfied that there is urgency in the present case. The court adds, with respect to the criteria of irreparable prejudice and urgency, that the fact that Mr. Jadhav could eventually petition Pakistani authorities for clemency, or that the date of his execution has not yet been fixed, are not per se circumstances that should preclude the court from indicating provisional measures. The court concludes from all these considerations that the conditions required by its statute for it to indicate provisional measures are met, and that certain measures must be indicated in order to protect the rights claimed by India pending its final decision. Under the present circumstances, it is appropriate for the court to order that Pakistan shall take all measures at its disposal to ensure that Mr. Jadhav is not executed pending the final decision in these proceedings, and shall inform the Court of all the measures taken in implementation of the present order. The Court reaffirms that its orders on provisional measures under Article 41 of the Statute have binding effect and thus create international legal obligations for any party to whom the provisional measures are addressed. The decision given in the present proceedings in no way prejudges the question of the jurisdiction of the Court to deal with the merits of the case or any questions relating to the admissibility of the application or to the merits themselves. It leaves unaffected the right of the governments of India and Pakistan to submit arguments in respect of those questions. For these reasons, the Court first unanimously indicates the following provisional measures. Pakistan shall take all measures at its disposal to ensure that Mr. Jadhav is not executed pending the final decision in these proceedings, and shall inform the Court of all the measures taken in implementation of the present order. 2. Unanimously decides that until the Court has given its final decision, it shall remain seized of the matters which form the subject matter of this order. I shall now call on the Registrar to read the operative part of the order in French.
Par ces motifs, la Cour, 1. À l'unanimité, indique à titre provisoire les mesures conservatoires suivantes. Le Pakistan prendra toutes les mesures dont il dispose pour que M. Jadhav ne soit pas exécuté tant que la décision définitive en la présente instance n'aura pas été rendue et portera à la connaissance de la Cour toutes les mesures qui auront été prises en application de la présente ordonnance. 2. À l'unanimité, décide que, jusqu'à ce qu'elle rende sa décision définitive, la Cour demeurera saisie des questions qui font l'objet de la présente ordonnance.
Judge Cansado Trindade appends a separate opinion to the order of the Court. Judge Bandari appends a declaration to the order of the Court. The text of the order is available from today in typescript. It will be available shortly on the Court's website. The printed text will be available in due course. As the Court has no further business before it today, I declare the sitting closed.